Welcome, Solid Source. I'm thrilled to be joined by Heema Patel, one of our in-house attorneys here at Solid Source, and we are going to be discussing changes to the 2023 GAR contract forms.
Welcome to the Real Estate Game Plan Podcast, where we bring you inspiration, actionable steps, and knowledge to build your game plan to take your real estate business to the next level. My name is Demo.
And I'm Derek, and we are licensed real estate brokers and your hosts for this podcast. Let's get started. Without any further ado, let's go ahead and hop into it. And the first change, Heema, you'll have so much more to add on this than me, but is disclosure of FIRPTA affidavit requirement has been added. And what it says is FIRPTA, or the Foreign Investment in Real Property Tax Act, is a federal tax law passed in 1980. And basically, this disclosure helps to avoid surprises at closing. So can you talk to us a little bit more about FIRPTA and why GAR made this change?
Sure. So FIRPTA is a federal tax law that basically says if you are a foreign resident or a foreign person, rather, then you are subject to at least up to or at least 15% of the purchase price, not the net gain, but the purchase price of the property. So as you can imagine, and the prices that we're seeing, in today's market, that is going to be a substantial sticker shock at closing if this wasn't already, disclosed to the seller that you're going to be responsible for this. There are a couple of exceptions to the FIRPTA tax withholding. And one of them is if you pass the substantial presence test, and there's a whole calculation you can find on the IRS tax website that basically says if the seller has been here or has substantial presence in the United States for a particular amount of time, they're exempt from that withholding. Typically, you're going to probably see that the seller has a tax ID or a social security number. That's usually going to be enough, but you'd always want to, share with them the calculation, and they'll have to determine that with their tax advisors. Another exemption is if the property is less than $300,000 or less, the purchase price, and the buyer is going to reside there as their primary, you use that property as their primary residence, and they're willing to sign what's called a buyer's FIRPTA affidavit, then the buyer would not be required to withhold that from the seller. Now, keep in mind, this is a buyer liability. So the U.S. tax law puts the liability on the buyer to withhold that from the seller. Otherwise, they're going to be liable for it if, the seller never files their taxes at the end of the year or tax returns and claims the capital gains if there are any.
What about a 1031 exchange?
That's a great question. 1031 exchanges would help them defer that tax liability if they were able to find a substitute property.
Awesome. And as an agent, you are not expected to know all about this or to be an expert on this. There are certainly times when buyers and sellers ask us questions that we need to encourage them to seek out advice from the appropriate authority. Right. So this would be one that they would want to talk to a tax accountant about, and they can look up more independently.
Exactly. And just keep in mind, if you are a buyer's agent and you know that there are foreign persons buying this property, you just let them know that down the line they may have to address this tax liability, and to make those preparations ahead of time. That may affect how the buyer takes title to the property, and we can go into that a little bit later in another segment, but that would be prudent for you to do as a buyer's agent.
Nice. Now, another change that GAR has made, and I love all the changes this year, but they're really more clarifications. And so I think that these are going to be super helpful. But another one are fees paid by the buyer and the seller at closing has been clarified. So just goes over that the seller agrees to pay the cost of the closing attorney to prepare and record title curative documents. Seller not attending the closing in person makes sense. Payoff and proceeds, handling and delivery. Then on the buyer side, buyer pays Georgia property transfer tax, the cost to search title and tax records, all other costs, fees, and charges, except as otherwise provided, all other title fees and post-closing fees. Anything you want to add on that? That's pretty straightforward.
It's pretty straightforward, and this was always embedded in the GAR contract. It's just clarifying. It's just elaborating what those fees may be.
Right.
But if you've been closing for a while, just know that this is how it's been handled by closing attorneys, for a while. So there's nothing new that you're going to see on the settlement statement because of it.
Right. Now, when it comes to closing costs, it's important to remember that any unused portion of that contribution remains the property of the seller. For example, seller agrees to contribute $5,000 toward the buyer's closing costs, and their actual closing costs are only $3,500. That extra $1,500 is going to remain with the seller. A lot of times buyers can figure out a way to use it, but just know that any excess will remain with the seller. And if the buyer has agreed to pay commission in the buyer brokerage engagement agreement, and the seller is not paying the full amount, that difference the buyer could pay and could use, I hope I'm not making this sound too confusing, the buyer could use that portion that the seller has agreed to pay to go toward that. So seller agrees to pay $5,000 in closing costs, and maybe there's that $1,500 excess, but the seller's broker is not paying as much as expected. That portion could be used to pay the buyer's broker's commission.
Basically, it's to say that any difference in the commission paid by the seller can be covered as seller contribution of closing on the buyer's side. Now, the good news about this is that most closing attorneys, the way that they handle seller contributions or seller paid closing costs is they just use it as a lump sum amount. They don't itemize it or anything like that as to what the seller contributions are paying for. They add it as a lump sum credit on the buyer's end, and then all of the buyer's closing costs, any lender fees, any title insurance, home warranties, termite, any closing costs that the buyer has in relation to closing this transaction can be used. So oftentimes it's not a big deal. It's not going to really affect a closing. Most of the seller contributions, if not all, are going to be used.
Right. Right. And I think the last statement, and this article will include a link for you guys too, is on the Georgia Realtors website. GAR does an excellent job of putting out an article every year going through all of the changes that they made. So pretty cool. But the last sentence says, in other words, the seller pays for a limited number of specifically referenced items at closing, and the buyer pays for everything else.
Yep.
So moving along to language was added to clarify the duties of the closing attorney in all cash transactions where the attorney is representing the buyer. Now, in general, the closing attorney represents the lender when there is a lender involved. Now, that's a contract that's baked into the boilerplate language of the GAR purchase and sale agreement. But if there's not a lender involved in the deal, then what the contract basically says is the closing attorney represents the buyer. But maybe there was confusion over representing the buyer and what the actual obligations, duties of the closing attorney was. So really, when I look at this and what GAR has done this year, I think basically they are simplifying and saying, look, we are helping to facilitate the closing, prepare the documents, but we're not actually advising the buyer. What would be your take on this?
I actually love this provision or this clarification because I think when you reference somebody as a client or that, hey, the closing attorney represents a buyer in a cash transaction, you think of it as an attorney, they're going to be advocating for me as a buyer. Right. They're going to be negotiating for me. They're going to be going to bat for me if there are any contractual changes. And so I think they were expecting closing attorneys to get involved in the transaction to, negotiate for them with other agents and sellers. And I love that this just limits it and it just puts it out there and says, listen, we're here to provide you with the closing documents, issue title insurance policy, and clear your title. We cannot negotiate on your behalf, and we're not representing you in the same capacity that you normally would be, without this limitation.
Right, and that makes sense, and I can totally understand when someone sees that language in the purchase and sale agreement, the closing attorney represents the buyer in cash. You would think that.
Yeah.
So great clarification there by GAR. Now, let's talk about inspection and due diligence. So this section was revised again for clarification, and I love this, and I will just kind of start this off saying that there has been confusion in the past by sellers and listing agents that may have the idea that if there is no due diligence period or if the due diligence period has expired, that the buyer cannot access the property. Their professionals cannot access the property. If there's no due diligence, you can't come out and look at it. That is absolutely not what the GAR contract says. A buyer has a right to inspect the property at any time prior to closing. Most common example of this is a final walkthrough. It's so common we don't question it. But buyers do have the right reasonably to access the property. So this clarifies that, and it also talks about damage to the property that may be caused. So rather than the buyer having the duty to restore the property, they actually pay the seller what the cost would be to restore the property to the condition that it was before the damage took place.
Right. And I think what they've done is they've added that language about, the actual cost incurred by the seller to restore it in substantially the same or the same condition as it was prior to. And it's going to be interesting to see how this provision plays out, just because, we've seen where there's sellers who have buyers who do inspections, and then 2 days later they discover something has been broken or damaged, and then, they blame the buyer, and the buyer doesn't know about it or anything like that. So it's going to be interesting to see how this one plays out, in my opinion.
And it's usually, may not be the buyer. It may be their professional, again, their home inspector, or another professional that came out that actually causes the damage. But GAR made this section in their contract now in boldface, so that way it's a little bit more difficult later to say that you didn't understand it, you didn't read it. It's there, it's in bold. What GAR is saying is this change was made so the seller could control the repairs being made to the property. So instead of, hey, buyer needs to repair the property back to the same condition, the seller can be the one with those funds and in complete control of that. Now, the agency section of the contract was tweaked again for some clarification, because it really boils down to who the broker represents in the transaction, not just who the agent. The agent is an agent of their broker. So let's just say, for example, and this is an example that Seth Weissman, who is general counsel to GAR, recently gave in a class on this. He said, well, if the listing agent or the listing broker is Solid Source Realty, and we have a listing agreement with the seller, they are our client, and another agent with Solid Source Realty is working with the buyer as a customer, that technically the buyer's agent and the seller's agent are both working on behalf of the seller.
Exactly.
Because those brokerage relationships are through the broker. It's always been that way.
It has always been that way. It's just been clarified, I think, a little bit better.
It's been clarified better. A little bit more on agency, just because it can be a confusing thing. Dual agency and designated agency. Now, at Solid Source, we do not offer dual agency. The Georgia Real Estate Commission themselves has even stated in their newsletters and so forth that they don't recommend it, even though it's up to the brokerage company to make that decision if they offer that or not. And that would be technically the same agent on both sides of the deal with the client relationship. If it's the same company on both sides, Solid Source Realty, and two different agents have client relationships, that is what we refer to in Georgia as designated agency. That would not actually be dual agency.
Yep. And that's a good point, Derek, just because we have, Solid Source Realty Inc. and Solid Source Realty Georgia. Right. You're very rarely going to see that type of relationship or agency, because you're technically two different brokerages.
It's not as common as you would think. Yeah. It really isn't, because of us having both of those companies, but it happens. And another point that Seth made was about transaction brokerage. And what is a transaction brokerage? A transaction broker is just a broker, an agent who doesn't represent anybody in the deal. Everybody's a customer. The example that I gave earlier about the listing company being Solid Source Realty and the buyer's broker being Solid Source Realty, but customer on the buyer side, that it's common for that agent maybe is working with the buyer to think, well, I'm a transaction broker in this, but technically they're not, right, because their company is representing the seller. But there certainly are times when a company is involved typically more for sale by owner, maybe a tenant's buying a property where transaction brokerage could absolutely be the case. So,
Yeah, I think
great.
the important thing to note is just brokerage agencies and brokerage agreements are between the broker and the client, not the agent themselves. So you have to look at that brokerage relationship.
Absolutely. A unique feature of the GAR contract is the 8-day right to extend the contract. And GAR made a clarification on this as well and said, look, if the financing contingency has expired, the buyer or seller, but still has a right to use that 8-day extension for qualified reasons. It doesn't go away just because the financing contingency ended. So I personally didn't see too many issues with that. No. Obviously, the GAR Forms Committee they listen to agents and brokers from across the entire state. So just because we haven't necessarily experienced that as a problem here in the Atlanta area doesn't mean that Savannah or Columbus or Athens hasn't experienced that. So that was clarified. What survives closing was technically clarified just a little bit to just say that to include buyer's obligation to indemnify the seller for damage done to the property by the buyer or the buyer's representatives. In general, nothing survives the closing unless we specifically state that it does. Mm-hmm. So even though we don't recommend repairs made post-closing, in the event we were doing an amendment for repairs post-closing, it would be super important. We would recommend that language be very clear on that amendment to state that it survives the closing. So moving along here to temporary occupancy agreement after closing, it was revised, and temporary occupancy is usually something that we really try to avoid. I would even say that in most cases, extending the closing date is better if you need to, so that possession really can be given at closing. A buyer moving in before closing is riskier, in my experience, than a seller staying in the property for a few days after closing. But this section was revised just a little bit as well. And it says the reason why they made these changes was to strengthen the rights of the buyer purchasing the property and to include in the form more provisions that are typically found in leases. And I'll have a few comments on that too. But it says, first, the seller's duty to give the buyer keys was expanded to also include door openers, access codes, security system codes, and other similar equipment or codes to access the property. Secondly, the seller now remains obligated to perform all routine maintenance during the seller's occupancy of the property, including but not limited to cutting the grass and maintaining pool chemicals. Obviously, a duty for the seller to also report any obvious needs for maintenance. And then finally, a bold-faced disclaimer was added advising the buyer and seller to consult with their respective insurance agents. This is really important and something that I think can very easily be forgotten about when we are thinking about these temporary occupancy situations at first, but they have a duty to consult with their insurance agent to confirm that their real and personal property is insured during that temporary occupancy agreement. Again, we're not insurance agents, but still something important for folks to look into.
Yeah, definitely. And I think buyers forget that because it's such a short period of time that the seller is retaining possession of the property, that really it's essentially you're entering into a landlord-tenant relationship at that point.
Right.
So those same classic provisions that you see in lease agreements, they should, I think GAR did a great job in including those in the temporary occupancy just to kind of elaborate on what those rights and obligations would be if you were under a landlord-tenant relationship.
Absolutely. And one of the things that the form actually has listed on it is not to be used if the occupancy period is greater than 60 days, because at that point you absolutely would want to enter into a lease. And really, I think it has to do with most lenders are going to want you to take occupancy.
Most lenders do have a requirement that if it's your primary residence, that you take possession of the property as a buyer within 60 days of closing out the loan. So if you're giving possession to the seller for more than 60 days, you can't obviously fulfill that requirement. So you would be in default or breach of your loan.
Now, with the temporary occupancy agreement, another thing that GAR has done is they have clarified the holdover rent section. So if let's let's just say the seller has temporary occupancy and it's for 5 days, and they now are thinking they may need a little bit more time, or maybe they just want a little bit more time. What is that penalty going to be? And what Seth has recommended is that that penalty be enough to deter the seller from staying there, because most hotels are going to be a couple $100s a night. So at least make sure that holdover amount is that much so that the seller thinks twice. Maybe it's more affordable to go to the Holiday Inn or another hotel than it is to simply stay in the property.
Yeah, I think it's important to note that the clause also mentions damages and expenses that are not related to just staying at a hotel or anything like that. It's, the cost of rescheduling the moving trucks or the delay in getting possession of the property, additional items that they may incur as a cost. And that holdover rent is only partially discussing those damages.
Right. So, good stuff. So, moving along to conventional loan exhibit. Now, I really love what they have done with the conventional loan exhibit. For one thing, they've put all the blanks to be completed on the first page. So, yay to GAR for doing that. We've been kind of they've been playing around with that idea for a couple of years, and it's finally been revised to be this way. It's really important on these loan exhibits to include the big three or the big four.
Yeah.
The amount of the loan, the interest rate, the term. Is it going to be your institutional, or is it going to be other or whatnot? Now, GAR made a change on the interest rate, and so now instead of it just being a blank, this is blank and then a percentage sign, it says not greater than the rate that's actually filled in, basically. So that, I think this is going to be extremely helpful, because especially when we're in a time where interest rates are kind of floating around a little bit, maybe it's 7 right now, but we're concerned it may be a little bit more, a little bit less, we can put a number there. So if the buyer's able to get that interest rate of 7 or less, then the buyer is covered, the seller is covered. It's only if the interest rate is more than that, that the buyer may have a way out of the contract during their financing contingency period.
Yep.
So that eliminates, I think, some of the issues that we've been having.
I think it's
with
just,
that.
it clarifies a lot of the confusion where you just put in a blank interest rate and you think that if you don't get this interest rate that you would be able to terminate.
That exact interest rate.
Like that exact interest rate, where really what GAR meant was if it's lower than that, you're still obligated to purchase a property, but if it's higher than that, then you're not. And I think this is doing the same thing. It's just putting it in clearer terms.
Right. So. Well, we love clear terms when it comes to contracts.
And just a reminder, do not put TBD. Do not leave it blank.
No.
You need it to be a valid financing contingency. You would want to put that in there for your, you would definitely want to indicate that for your buyer. And as a seller, it would help you get a stronger buyer if that was indicated as well.
Absolutely. And not to be fearful, but Seth has mentioned if one of those big 3, big 4 are not filled in, and maybe TBD is put there, the entire contract, if a judge or is looking at it, may determine that the whole contract's void, which that would not be fun.
Contingency.
At least the contingency. So good deal. Now let's talk a little bit about the seller's property disclosure statement. So that was modified too. It says to clarify, once the property is under contract, the fixtures checklist cannot be rewritten or change what items remain with the property or goes without the permission and consent of the buyer. Sellers, of course, are required to update that seller's disclosure statement throughout the deal if things change. So seller's property disclosure statement to update defects in the property does not extend to changing the fixtures and personal items. So good job with that clarification there. Now, exclusive seller listing agreement, pretty common form to fill out when listing a property. They did add a new lead-based paint disclosure. So lead-based paint is a big deal. So EPA does require that if a property was built before 1978, it's considered a target property, before a buyer is obligated to purchase that property, they are required to receive a lead-based paint pamphlet and a disclosure from the seller revealing any information the seller has about lead-based paint. And GAR has a specific lead-based paint disclosure exhibit. So good tip here for listing agents: when you're listing a target property, go ahead and let the seller know that. It's baked into the listing agreement now. And go ahead and give them that exhibit. Have them fill it out now. Go ahead and make it an exhibit in an attachment to your listing in the MLS. It's actually not hard to do that pretty easily, and then that way the buyer's agent has it up front, because you don't want a buyer's agent to be in a situation where they have a buyer that wants to make an offer on a property and they need that lead-based paint. Maybe, we've told them, their brokers told them, they know from classes that it's so important, because the EPA can fine, I think it might be $16,000 per violation. Ned Blumenthal, when he's talked about this in the past over at Weissman, has called it the very expensive form. I think he may call it the $250,000 potential exhibit form. It can be very costly, long story short, to not get this right. So super important to get it up front. So
I personally love this change that it was added into the listing agreement. I think it's going to remind listing agents, it's going to remind the sellers, hey, this is something that I need to do, and I need to do it before I go under contract. I think that's the important part to know, is that you can't do it after the fact. You can't do it after the parties have gone binding. This is a form that the seller needs to provide to the buyer before they can even, go under a contract.
Right.
So, because even if you do it after the fact, you've already violated the lead-based paint, disclosure act. So it's absolutely the number one most important thing I would stress to agents, because it comes with a hefty price tag if you violate it.
Yes. And if you are a Solid Source agent and you're watching this and you want further clarification or want us to review, these things further, please do feel free to reach out to us. We're always happy to help. That's what we're here for. So more clarifications here. So language was added to that listing agreement, so still within the listing, regarding brokers who are not members of an MLS. So it says, seller's broker shall have no obligation to pay any cooperating broker who is not a participant of the MLS in which the property is listed a commission, unless cooperating broker has negotiated and executed with the seller's broker a co-op commission agreement. So basically, as members of the MLS, and we're members of FMLS, Georgia MLS, and so forth, if the brokers are members of the MLS, you have that assurance that the commission being advertised is going to be paid. But let's just say that you are working with a buyer, and that buyer is interested in a property that's in an MLS that you or your broker is not a member of. We have no way of knowing what the co-op commission would actually be. Maybe there's not even a co-op commission. Maybe the buyer's willing to pay it, and that's great. But it would be really smart at that point, and I would recommend getting a co-op commission agreement signed to confirm. Because, again, you don't want those kind of surprises to come up after the fact.
Yeah, definitely not at the closing table.
Yes, definitely not for sure. So I want to move on and talk about the cash exhibit. Now, the cash exhibit is getting a new name this year, and it's going to be called the No Financing Contingency Exhibit. And maybe, all things considered, this is a more appropriate name for it, because it can be used when a buyer truly is purchasing a property with cash, or if they are electing to waive their financing contingency. And so, coming out of the extreme seller's market that we've been in for the past couple of years, negotiating is coming back and so forth, but we were seeing a lot of buyers using the cash exhibit who really wasn't cash. They truly were just simply waiving their financing contingency, and they were using that form, which led to some confusion again. So again, GAR makes these changes based on recommendations and issues that they see to help everyone. So now it's going to be called the No Financing Contingency Exhibit to avoid confusion. But the form still will have the option that will allow the buyer to get a mortgage if that is what is selected. The buyer could still select the option to have an appraisal and so forth. Really, my big advice on this is, if a buyer is making an offer with a exhibit, no financing contingency exhibit, that we go ahead and get proof of funds.
Yep.
So we know, because if it's going to be cash, they typically will be able to provide those proof of funds. And if not, tell me more.
Yeah. I don't suspect that this will change a lot of things for listing agents. I think they're still going to require it. Being good listing agents, they're still going to require proof of funds from the buyer. So if they know that, they can't purchase it in cash, they're going to want something else to show that they have the ability to close on the loan.
Right. FHA loan contingency exhibit. So this is a change that when I first read about it, I wasn't completely sure how I felt about it, and I kind of went back and forth. But I feel like at this point, having thought about it a little bit more, this is a good change that GAR has made. And so essentially, with FHA and VA, there is an appraisal contingency that's going to be baked into that loan exhibit. GAR puts all of their appraisal contingencies on the loan exhibits. And with FHA and VA, with FHA and VA, the appraisal contingency is called a mandatory clause. Mm-hmm. So that can trip a lot of us up because we're looking for a paragraph to specifically be titled appraisal contingency. And it's not. It's called a mandatory clause. And it basically would say that if the property does not appraise for the contract sales price, the buyer can walk away, basically is what it's going to say. That's a lender requirement. Most lenders will have their own amendatory clause, very similar to the language in the GAR financing exhibit. But what GAR has done in their forms now is they have stated if the property does not appraise and the seller agrees in writing to reduce the price, then we're all moving forward. The buyer cannot come back later and say, hey, I'm not going to close because the property didn't appraise, which is fair. The seller agreed to reduce the price, and now the contract price does match the appraised value, and so everyone is moving forward. So,
right. I think this was just an attempt to save the deal, right? As agents, as buyer, seller, hopefully buyers, and lenders, we just want to make the deal work. We want to get it closed, and I think this allows people, buyers and sellers to do that, and buyers not to walk away for simply another reason that's not financing related or appraisal related, and be able to get out because of that clause. We'll see how it plays out with FHA and VA if they have any issues with that change in the amendatory clause. But for now, I think it's a pretty good clause. I will say that as agents, be mindful when your seller is sent to sign the lender's FHA certification or amendatory clause after this contract has been signed, as it may amend this particular term. So I think definitely reach out to us to discuss that, and we can figure out an alternative.
Okay, so just a few more changes, and the next two we're going to deal with disclosure exhibits. So with the community association disclosure, it says the type of community association in which the buyer will be purchasing was clarified in the 2023 form. Specifically, a new category of community association was added, consisting of a voluntary transitioning to mandatory association. So there is then a box to select whether the buyer will be a voluntary or mandatory member. While there are not a huge number of such associations, many voluntary homeowners associations have tried to become mandatory associations and often go through a transitionary period. So that's nice to know. So it gives the seller an opportunity to disclose if that's the case. Condominium, seller's property disclosure exhibit, rather. It says this exhibit was modified slightly to try to disclose to buyers the age of condominium units. So two new questions were added. One, what year was the building in which the unit is located originally built? And B, what year was the declaration of condominium recorded?
All right, so Derek, I can already anticipate the number one question we're going to get about this, and is how do I know what year the declaration of condominium was recorded? And rightfully so, most sellers are not going to have that information. You would find that information in the legal description of your deed or of the seller's deed, so that would be a good place to look at. Reach out to our closing attorney, Weissman, and see if maybe they could pull that declaration of condominium to see when it was recorded or filed. And that would be a good way for you to get that information for the seller.
Excellent advice. And then the final change here is regards to the lease for residential property. So they are adding a disclosure in regards to radon. So we recently had a coaching session regarding this, but radon essentially is there's no way to detect it without having a test done. You can't see it, you can't smell it,
Can't taste it.
taste it, anything. And in the Atlanta area, in the North Georgia area, there is a tendency for high levels of radon. And based on what we've been told, that 1 out of every 15 homes has an increased risk for this. And it is a leader in the cause of lung cancer.
Yep.
So it is something to take seriously. There's not currently any legislation in Georgia requiring it or requiring the disclosure of it specifically, but there are in some states, and there could be in the future. So
it was surprising to learn just how many cases of radon or, radon tests came back for the metro counties. And it was astronomical, I thought, for not having legislation around it. So
Right. We'll include a link in the description for you guys as well if you're looking at that. We had a gentleman from the University of Georgia, an educator, come on and provide a class to us in a coaching session on radon. It was very, very educational. And finally, GAR did include a link to the Georgia Landlord Tenant Handbook. So at Solid Source, we do not offer property management. That's no secret. But we do have agents that will work with tenants and landlords from time to time. And essentially, the Landlord Tenant Handbook puts things in very simple terms, easy to understand, and goes over really just Georgia landlord tenant basic law that's so important. And so it's easy for folks to reach out to us with questions post leasing, and we're not necessarily experts on that, but the link to that Georgia Landlord Tenant Handbook can be very, very helpful to both tenants and landlords.
Yes, and as agents, just be careful not to provide any legal advice unless you're a licensed attorney and you represent one of your clients in that capacity, but be careful not to advise them on any laws or rules that you think you understand about the landlord-tenant relationship.
Right. Good advice. Heema, thank you so much. This was awesome. Your insight is always extremely helpful to everyone. And again, GAR contract forms. These are the full list of changes for 2023. And again, we'll include a link to the full article in the description for you guys. If you are a Georgia realtor, you have access to the contract forms. And if you are not, but you would like access to them, again, that website to purchase a license for the year is forms.garealtor.com.
You've been listening to the Real Estate Game Plan Podcast. Don't forget to like and subscribe on YouTube and leave us a 5-star review on your favorite podcast platform. Thank you for listening.